Hello everybody. This is part 3 of Hindu Marriage Act 1955. And section 27 says, in any proceeding under this act, the court may make such provisions in the decree as it deems just and proper with respect to any property presented at or about the time of marriage, which may belong jointly to both the husband and the wife. And section 28 says all decrees made by the court in any proceeding under this act shall, subject to these provisions of subsection 3, be applicable as decrees of the court made in the exercise of its original civil jurisdiction, and every such appeal shall lie to the court to which appeals ordinarily lie from the decision of the court given in the exercise of its original civil jurisdiction, and orders made by the court in any proceeding under this act appealable if they are not interim orders, and every such appeal shall lie to the court to which appeals ordinarily lie from the decisions of the court given in exercise of its original civil jurisdiction, and there shall be no appeal under this section on the subject of costs only. Every appeal under this section shall be preferred with a period of 19 days from the date of decree or order. And section 29 says a marriage solemnized between Hindus before the commencement of this act, which is otherwise valid, shall not be deemed to be invalid or ever to have been invalid by reason only of the fact that the parties thereto belonged to the same gotra or pravar, or belonged to the different religions, caste, or subdivisions of the same caste. Nothing contained in this act shall be deemed to affect any right recognized by custom or conferred by any special enactment to obtain the resolution of Hindu marriage, whether solemnized before or after the commencement of this act. Nothing contained in this act shall affect any proceeding under any law for the time being in force for declaring any marriage to be null or void, or for annulling or dissolving any marriage, or for judicial separation pending at the commencement of this act, and any such proceeding may be continued and determined as if this act had not been passed, and nothing contained in this act shall be deemed to affect the provisions contained in the Special Marriage Act 1954 with respect to marriages between Hindus solemnized under that act, whether before or after the commencement of this act. Next point is Marriage Law Bill 2010. The Marriage Laws Amendment Bill 2010 to amend the Hindu Marriage Act 1955 and the Special Marriage Act 1954 to making divorce easier on the ground of irretrievable breakdown of marriage was introduced in the Parliament in 2012. The bill replaces the words "not earlier than 6 months" in section 13 of clause B with the words "upon receipt of a petition." It also provides a better safeguard to wives by inserting section 13D, by which the wife may oppose the grant of a decree on the ground that the dissolution of the marriage will result in grave financial hardship to her, and that it would in all the circumstances be wrong to dissolve the marriage. And the Marriage Law Amendment Act 1976, in this amendment, the new section 13 of clause IA, the Hindu Marriage Act, laid down that if parties have not resumed cohabitation for a period of 2 years or more after a decree of judicial separation, or if a decree of restitution of conjugal rights has not been compiled with for a period of 2 years or more, then either party may sue for divorce. In the Marriage Law Amendment Act 1976, Section 21 of Clause B, added in 1976 amendment, and direct the court that proceeding to family related and in 6 months for district court and 3 months for appeal court from the date of service of notice. And Section 17 removed in Amendment Act 1976, and time reduced from 2 years to 1 year for judicial separation for restitution of conjugal rights. And Marriage Law Bill 2010. In this bill, new section 13 of clause E provides restriction on decree for divorce affecting children born out of wedlock and states that a court shall not pass a decree of divorce under section 13C unless the court is satisfied the adequate provision for the maintenance of children born out of the marriage has been made consistently with the financial capacity of the parties to the marriage. Marriage Law Amendment Bill 2010 makes similar amendments to the Special Marriage Act 1954 by replacing the words not earlier than 6 months in section 28 with the words upon receipt of a petition, and provides restriction on decree for divorce affecting children born out of wedlock. However, there was opposition to this bill due to the objection that it will create hardships for women and that the bill strongly supports one party while both parties should be treated equal in divorce. Therefore, the bill was amended to provide for the wife's consent for waiver of 6 month notice with the words upon receipt of petitions by the husband and the wife. Now, study some cases. First case is Saroj Rani versus Sudarshan Kumar, 1984. The Supreme Court validated the constitutionality of Section 9 of Hindu Marriage Act in Saroj Rani versus Sudarshan Kumar Chadha, 1984. The court held that the respondent shall follow the matrimonial obligation and cohabit with the petitioner. The court also stated that if in case the respondent fails or willfully fails to comply with the decree within 1 year, then the petitioner has the right to file a case for divorce under section 13 of Hindu Marriage Act. And next case is Anantrao Adha versus Anantrao Shivram, 1988. In this case, court observed that any marriage that appeared to be non-observance of section 11 of the Hindu Marriage Act 1955 are to be treated as null and void from the very beginning of the act. To understand the objective underlying this condition, a simple reading of the condition stands enough. The prevalence of bigamy in Indian society for several decades has been a clear reflection of the patriarchal framework in Indian society. The motive behind the condition is therefore to eliminate such practices entirely. Working in line with section 494 and 495 of the Indian Penal Code 1860, which recognize bigamy as a non-cognizable offense with a deterrent of 7 years imprisonment and or fine. The Hindu Marriage Act 1955 also ensures no such activity to take place in the society as laid down under section 217 of the Act, thereby making the practice of bigamy non-existential. Now the conclusion is the Hindu Marriage Act provides guidelines for Hindus to be in a systematic marriage bound. It gives meaning to marriage, cohabiting rights for both the bride and groom, and a safety for their family and children so that they do not suffer from their parental issues. Thank you.